Good afternoon. Welcome on in to another episode of From Day One. The courts are ready. And today we're on the call with me, woman Angela, who claims that she is not a defendant. Now we're just listening to the cases with Mike. So we will have a few cases coming up before them, more than likely, as we rock through Dominion.
Competent was sent to the Forensic Center for treatment and evaluation. And through treatment, they determined that he was rendered competent. He's been returned to our county, and we are now ready to proceed with these cases. It's up for a docket call of both files.
Mike, can you adjust the audio?
Good morning, this is Attorney Mike Grevin coming to you from Chicago. As usual, I'm trying to catch our woman in common law, Ms. Christensen, and I got a last-minute note from Old Squishy Gardner. Shout out to Old Squishy Gardner. I think she's up in a couple minutes here. I only have a few minutes, so hopefully we catch it.
Sounds good, Mike.
You know how we're proceeding, Gilbert? Yes. No, Judge. Yeah, I can continue this to the July 11th date at 10 a.m.
Thank you very much, Your Honor.
Mr. Gargo, we'll see you then, sir.
Any questions? You have any questions for me? No. Okay. Good morning, Your Honor. James Gilbert here on behalf of Mr. Workman.
All right, this is from page 5 of our docket. People of the state of Michigan versus Robert Workman. It's file 21-93188FC. And this is a case that is scheduled for a jury trial on July 14th and 15th. We set it for a docket call today to see if there were any issues before then. Mr. Gilbert, do you know how we're proceeding today then?
Yes, Your Honor. We'd like to leave it on for the trial from 14th to 15th, Your Honor.
Okay. So what we're going to do is conduct jury selection at the Belknap Township Hall. And then we'll at least do selection and initial instructions and opening statements that day. Perhaps at the Belknap Township Hall. If jury selection goes smoothly and we're done before lunch, what we might do is take the lunch break and tell the jurors to continue back in the courtroom and do our instructions and statements out here. Mr. Gilbert, Mr. Redson, if you want to communicate if you want to have one possible witness ready that day, that's up to you. But what we can do is give the second day, a little early, tell them to arrive at 8, start at 8:30. We'll do the trial back here. Have witness and exhibit lists been exchanged?
I believe so. We don't have any witnesses other than that contained in the police report, but
All right, while we're waiting for the main event to kick in here with woman Angela, the echo you're hearing is because of the court setup, trying to cover both regular Zoom participants and people in the courtroom, both at the same time. And the microphone's picking up both from the judge's mic and the either prosecutors or defense's table. Just in case you wonder on those.
So maybe could especially a lot of times in the CSC cases, the instructions can have little details that become important. So could I ask for jury instructions by Friday, July 1st for both of you?
Absolutely, Your Honor. And Your Honor, you asked about witness list Yes, I'm not sure if I had submitted mine yet, but my only witness is my client.
Okay, and the prosecutor indicated his only witnesses are those listed
Other
on the.
takes Vic to lose, Your Honor.
Oh, and I do see there has been a prosecutor's witness and exhibit list filed.
That's correct.
Okay. All right, so other than jury instructions by July 1st, anything else we would need to cover prior to trial, gentlemen? Okay.
I don't believe so, Your Honor. Thank you.
Okay, thank you. We'll see you out there at the hall then. What we'll do is we'll have the jury. What have we done out there? We did it before. Have the jury arrive at 8:30 and begin selection at 9.
Yes.
Okay. So that's what we'll do. We'll have the jury arrive at 8:30 and the selection begin at 9. Of course, Mr. Gilbert, you'll make sure there's clothing arranged for Mr. Workman, and we'll arrange to have him out there before the jury.
I'll do that. Thank you.
Okay.
All right, hopefully this is it.
It better be.
Good morning, everybody. Nice to see you all with my surprise attack live stream.
We like you, Mike.
Come on, Judge. I don't have time for wild goose chases today.
Yes, you do. Australia in the house. G'day. Hey, we got an Aussie. Yay. We like Aussies.
Yeah, it just got handed on.
I didn't get a notice of that. Okay, that's fine.
Good morning. Are you Anthony Grace?
Yes, sir.
All right. This is People versus Anthony Grace, file 22.
You lied, Mike.
206 FH. It's an arraignment. Mr. Grace is appearing by video. The prosecutor is here in the courtroom, as is the defense attorney, Mr. Vogler. Mr. Grace, we do provide public access not only in the courtroom but also online. And this is your arraignment. What's that?
What's public access for?
Oh, because it's open to the courtroom, open to the public courtroom.
Y'all are starting early, huh?
We've been providing for the last couple of years access not only in the courtroom but also online. So this proceeding and all my criminal proceedings are on YouTube.
Okay.
All right, and this is an arraignment. Have you gone over the charges with your lawyer, sir?
Yes, sir.
Mr. Vogler, would you like the allegation read?
I would, Your Honor, because I don't recall.
Okay, this is okay. So, Mr. Grace, you're charged in count 1. It's a one-count information. It alleges that one Anthony Michael Grace did knowingly or intentionally possess the controlled substance buprenorphine, contrary to Michigan law. There's also been a habitual offender second offense notice alleging that you have a previous felony.
I don't even know what that is.
2011.
Drug,
Second
Mike.
degree in Livingston County Circuit Court.
Drug offense.
The penalty for that charge with the habitual notice would be a maximum of 3 years in prison and/or a $2,000 fine.
I think that means we got the UK here as well.
Mr. Vogler, how does Mr. Grace wish to plead to that?
Oh, you're talking
Which is
about
awesome.
people giving you quids.
They will enter a plea
Yes,
not guilty
those are
on
UK
his
currency
behalf.
pounds.
Is a forensic center referral requested?
No.
Estimated length of trial?
1 day.
Canada! Woo!
Trial on July 11th.
Ooh, a tasty Canadian. If you don't get that, you should watch my C
I'm
episodes.
sorry,
Or
would it be
Fails
July
reference.
11th?
It sure did.
Yes, July 11th at 9:20 in the morning. Now,
Tasty
Mr. Grace,
Canadians.
do you live in Novi?
Yes, I live in Novi. I moved up north last year to take care of my dad, but because of how sick I was, my insurance wouldn't work up north, so I had to move back downstate to take care of my health.
Okay. Mr. Ransabon, do you have any objection to a Zoom appearance by Mr. Grace at that hearing?
No, I don't.
Trash. And love it.
All right, Mike, get it out of your system.
All right, Mr. Grace, I'll allow you to appear by Zoom for that hearing with one exception. I mean, if you and your lawyer work out a plea, we would prefer to have you present in the hearing.
No, that's fine. I already talked to my father and let him know that I might be coming up north to stay with him for a day or two, and I don't have to drive up there, though.
Thank you, Lucy, but I don't really know what Suboxone is. I've heard of it.
Let's just sort that out with your lawyer then, okay?
Thank you.
Okay, anything further from the defense?
No.
Baker in the courtroom?
Alabama fixing to watch this here case.
Yes.
Nice to see you, Abby.
Right, this is from page 1. We have an arraignment in People versus Scott Baker, file 22-9320.
That explains it.
We also have scheduled it for a docket call on page 12, file 22-93199. I presume we'll handle both matters right now, Mr. Booker.
Yes, Your Honor.
Come on, call Angela.
The prosecutor.
I've got a schedule here, Judge.
Mike, not everything is on your schedule, dear. Just like you don't walk into a courtroom and tell Your Honor, hey, Your Honor, I don't want to sit around here and wait, call my client.
Demanded and ordered a transcript of the prelim to be done in this particular building case. I just spoke to the district court. That's not completed yet. The order to be done today. It's not done.
Là, c'est le bon temps relais.
Hey, stop getting fancy with the languages.
93200. Would you like the allegations read?
We'll waive the reading.
I crack myself a drink.
Your Honor, he pleads not guilty.
Letter of plea not guilty on his behalf is a forensic center referral requested.
No.
Like the trial. And docket call in both matters, the 93199 and the 93200, on July 11th at 9:30 a.m. in person. That work, Mr. Booker?
Yes.
All right, anything further from the defense?
No.
Other people?
No, Judge, thank you.
Okay, Mr. Baker, you're all set today, then, sir. And looks like we have Ms. Christensen in the Zoom meeting room to call that case.
Believe this is going to be yours, Mike, to finally make you happy.
All right, good morning, Ms. Christensen. Can you hear me?
Yes.
Okay,
It's on, people.
On page 4, People of the State of Michigan versus Angela Christensen. It is file 21-93185FH. Ms. Christensen is appearing with us by Zoom video. Her lawyer, Mr. Vogler, is with us in the courtroom today, as is the prosecuting attorney, Mr. Radsbach. This, Mr. Vogler, is a defense motion to quash the information and discuss the consent. I've reviewed the preliminary.
And this is actually a weird thing because the first time our woman Angela is actually appearing with an attorney.
Preliminary examination transcript, the motion to quash, and the people's answer to the motion. Go ahead and argue your motion, Mr. Vogler.
Yes, Your Honor. So this case, it started out, Ms. Christensen was a passenger in a motor vehicle that was pulled over on a county road in the Grand Lake area, and Ms. Christensen was seated in the back seat. The officer came up and asked the driver for his driver's license and registration and insurance. And the issue, as it developed, not sure who said it first, but I think it was the driver. I don't have to show you my driver's license. And Ms. Christensen began also arguing with the officer with regard to and telling the driver that he didn't have to show the officer his driver's license. Yes, I think Ms. it developed, the driver finally told the officer that he didn't have a driver's license. He was removed from the car, taken back behind the car he was in, standing between the patrol car.
Oh my God, she was a passenger?
Yes, Mikey.
The officer that it didn't stop, started a sobriety test. There came a point where Miss Christensen got out of the car. At best, what I see in this case, is I don't think that the arguing, telling the driver that he didn't have to show the officer his license, or arguing with the officer leading up to this point, I don't think that, under the case law, constitutes resisting, obstructing, assaulting under the statute. So you get to a point where the testimony is on page 9 and 10, where the officer that made the stop testifies in response to the question, did you give her any direction to get back into the vehicle? Answer, either I did or Officer Haskey did as well. But then the next question is,
Yeah? What about that? Hold on, we lost the track just a moment.
For example, police officers. Here, whether or not
Extremely ambiguous. Nice. Extremely ambiguous.
Yeah, I think here's about where we were.
nor had Officer Haskey, the other officer, do that either. And the reason I bring that up, because if we read further, there's a question and answer as to whether or not she in fact got back into her car, and the answer was no. So first I would say that it's extremely ambiguous there whether anyone told her to get back into the car based on the record, and whether or not
Extremely ambiguous. Nice.
an order that she had to obey public road. And I think the daughter later testified, Ms. Christensen's daughter testified that why she had gotten out of the vehicle, and that had to do with some anxiety or panic attack or claustrophobic type reasons. Based on the case cited in our no physical type action here by Ms. Christensen that would arise to crime. Hey, Mr. Redstone, people's response? Yes, thank you.
This is somewhat of an interesting factual scenario, Judge, because what we have here is we allege Ms. Christensen directing the physical action, or more appropriately, the physical non-action of the driver in response to the officer's legitimate request to produce identification. And this isn't just a one-time comment. This direction goes on for 9 to 10 minutes in the officer's recollection, and he testified to that. There's a continuous directive by her to the driver, do not comply and do not produce, and the driver did not produce for a long time. We think that is sufficient to constitute obstruction. The other argument here, Judge, is that
the information and dismiss the case based on the case of.
I do no such thing.
Yeah, the People v. Morris case. And in that case, there was a challenge to the resisting and obstructing statute on free speech grounds. And the Court of Appeals interpreted that statute to save it from constitutional problem by saying that this statute is designed to protect police officers and other people in identified occupations who are lawfully engaged in conducting the duties of their occupations from physical interference or the threat of physical interference. And the Court of Appeals said that state actors cannot, under this statute, arrest and convict persons for only utilizing constitutionally protected words in opposition to the actions of, for example, police officers. Here, it seems that the majority of the complaint that the officer had against Ms. Christensen was that she was arguing with him. She was maybe even swearing at him or calling him names. And you know what? That might not be super polite, but we don't have to be polite to the government. She had the First Amendment right to tell the officer what she thought of the situation. Even her directions to the driver, well, don't comply, don't obey. If the driver took that advice, the driver would be doing so at his own peril, to be sure. But her giving that advice, I think, would have to be protected by the First Amendment. So I think the bottom line is the words out of a citizen's mouth directed at a police officer would almost never be a felony crime. And this case is mostly the words that came out of Ms. Christensen's mouth. I mean, we've had her in the court when she was representing herself, and she's got very strongly held opinions about how things ought to be in the criminal justice system. I don't believe they're the correct opinions, but she holds them strongly enough that she doesn't always temper her words or behavior in a way that we would like. But that doesn't make it a crime. The closest thing here is that she gets out of the car during a traffic stop. She walks toward the officer. If the officers tell her, step back, and she continues into their space, causing them a risk of harm, well, that would be a felony crime. That'd be interference. There's really not much evidence of that. There's no evidence that she interfered with the stop physically or with a threat of physical interference. Mr. Vogler points out, did you tell her to get back in the car? Either I did or Officer Haskey did as well. Well, did you hear him direct her to get back in the car? I can't recall. Even on a probable cause standard, that just doesn't seem to be enough. I'm unsure. The parties haven't cited for me what authority would allow police officers to tell somebody to get back in the car. They could tell them to step back. So if she left where the officer was investigating the suspected drunk driver and stood at her car peaceably outside the door, I don't know whether it would be a lawful command to tell her, no, you can't stand there, sit your butt down in the car. I don't know, maybe it is. I haven't seen a case that tells me that. But I don't know that the evidence shows that happened. And even when I was reading the preliminary examination transcript, at page 10, Officer Deputy Eby says, was there any interference by Mr. Christensen while you're putting him in the patrol car? And he answers, yes. She continued to use expletives, giving the driver legal advice for the incident. And at this time, Officer Haskey placed her under arrest. I think it's apparent to me from reading this transcript that the officers were upset at Ms. Christensen's words, and they arrested her because of her words. That is constitutionally forbidden. I'm going to grant the motion to quash and dismiss this case. Yes. It is a dismissal without prejudice under the law, Ms. Christensen. So your attorney can explain to you if the prosecutor believes they have additional evidence, they can rebring the charges if they so choose. But there'd have to be some additional evidence. But as it stands today, I'm going to grant the defense motion to quash the information. This case is hereby dismissed. Ms. Christensen, you're discharged from any further obligations in this matter.
Thank you.
Okay, you have a good day.
Mike, you want to
too.
talk about this? Mikey?
All right, now, Mr. Vogler, on the docket call order, I have written on the bottom, defense motion to quash is granted. If you require an order in addition to that, you can submit one.
Wow, well, there you have it. Can you guys hear me? I was fighting the volume the whole time. I don't know if you saw that. That is not what I expected. But I didn't know because I never knew the facts of the case.
It also helps a lot that she actually finally decided to stop being a sob-sit moron and actually have a lawyer. You know, lawyers, and say, I hate to give you guys your credit, Mike, but you guys know what you're talking about and can way more work through a legal situation than a normal layperson.
I never knew what was going on in the underlying case because she would show up and spew so much nonsense. For the first time, and here it confirms it, for the first time she shows up to a hearing and has an attorney lay out the facts and an argument in a rational fashion. And it's not just because the attorney did it, but it's also the date for it. But if she would have started with "you don't have jurisdiction" and all this BS, it wouldn't have worked. The attorney looked at the facts of the case and attacked it and said, "Hey, all she did was say some bad stuff to a police officer. You shouldn't get arrested for that." That's a solid constitutional argument. That is, and I like the judge's analysis of this situation, and it's very typical. And you know, I mean, he's not emotionally involved because he's not worried about it. But this is a woman who's been nothing but rude to him.
Yeah, you can say that right.
Mostly, on balance, rude to him, and he's like, I don't care about that. What happened here? Let me apply the facts to the law. We never had any facts till now, at least from the perspective of watching this on YouTube. Maybe the judge had some more stuff in his file, but I imagine what happened here is that motion to quash is filed by an attorney, and he's setting it out. But now you have an argument to look at. Hey, this is vague. She hasn't really done anything that rises to the level of a felony, other than be non-cooperative and say things that people don't like. Okay, that's fine, but it's not a crime. It's annoying, but it's not a crime. So, you know, I did not see this coming, but it doesn't shock me now that I know what the facts are. Again, all of this, I'm sure sovereign citizens will take this as some great victory. It isn't. All the sovereign citizen stuff did was delay this moment. We could have gotten here in like the second appearance if she wasn't contesting jurisdiction and all this other crazy. If she would have just let him appoint the public defender, the public defender would have had an interview with her, said, wait, what the hell? You're a passenger, and I don't see the offense here. Let me file a motion for you. All of this could have happened like
yesterday.
Literally 2 weeks later, had she allowed an attorney to make this argument for her. Finally, an attorney did. Who did a nice job, except for the slow talking. I'm taking points away for the slow talking.
That's just because you wanted to get on with your day, Mike.
Job is a matter of law, but it wasn't very entertaining.
You just wanted to get on with your day. Wasn't a fast talking Chicago guy.
Confirm my faith in the judge here, who I just think is a reasonable guy. He's saying that as he laid it out. I can't argue with his analysis. I can't. We don't have anything that constitutes a crime. We've got an annoying woman. That's not a crime. If that was a crime, well, I won't say.
Yeah, careful, Mike. Do not track us both down.
There'd be a lot of people in prison. I won't say how many, but there'd be a lot more.
Mike. Is Mrs. Mike
I gotta
listening?
run and do my thing. Thank you guys all for the surprise deck. Thanks.
Thank you, Mikey. And with that, we will bring Part A to a close. Come back, of course, for our frauditors, auditors, soft-stits, and Karens. In the evening, I think we're going to have a bunch of fun there. And of course, then in the overnight, Art Bell to rock us through that overnight. I think we're going to probably go UFOs, but not exactly locked in on that yet. Till then, make sure you do like, share, and subscribe. Help get us to that goal of 50,000 views, 1,000 subscribers. 50,000 views will make Boxy over and Nexters turn loose with those nice red boxes, so that we can start sending them out to all of you lovely individuals. Coinbase, Ibotta, Gain.gg will go ahead and get you $10 free for the first two and the 100 credits free for the third. Use them anywhere you like, whether you like to get Valkyrie's Favor, other packages here in Dominion, as of course they do accept crypto or anything else you like. Here in Nexter's land. And until next time, like, share, and subscribe, be kind to one another, and as always, release the Krakens. As we march along this afternoon, and every afternoon here from day one. Have a great afternoon again. The auditors, frauditors, soft-stits, and Karens coming up on our next episode in the evening, usually around 8 p.m. GC time, 9 p.m. Eastern. Of course, adjust for your time zone. I believe it's 2 a.m. UTC. And until then, have a great afternoon. Again, we'll see you tonight. Have a great day, everybody.